William Eskridge Jr. is the John A. Garver Professor of Jurisprudence at Yale Law School. He got his bachelor's at Dickinson College, his master's at Harvard, and his law degree at Yale. He is an expert on legislation and statutory interpretation, and he also wrote one of the pivotal books on gay rights in American culture called Gay Law. That formed the basis of an amicus curiae brief that he filed with Lawrence v. Texas, and in fact was really influential in the opinions of that court. His most recent book is Gay Marriage, for Better or for Worse, and he's going to be talking to us today about the Perry lawsuit in California, which challenges Proposition 8. So please give a warm welcome to Professor Eskridge.
So what I wanted to do was we're going to aspire toward about 20-25 minutes. Professor Wilson back there will help me keep time. She's my host here who brought me here today, so I appreciate her kind invitation. I want to talk about two things. One is the background of the Perry lawsuit, just to give you some context. Secondly, the arguments as I see it in the Perry lawsuit. I'll have to be sketchier on the arguments on the other side because they've not presented their case yet, but we know the arguments on the side of Olson and Boyes, and then some critical comments. And then open it up to questions and statements and speeches and violent disagreements, etc. Now, here's the background. As you know, in the United States, traditionally, gays and lesbians have been criminals in the United States. When I was growing up in southern West Virginia, just a few miles from here, the assumption of most people who were gay and lesbian was certainly not that they were ever going to be married, at least not the same one of the same sex, but instead that they could be put in jail, they could be arrested, beaten, murdered. So there's been a sea change really in the last 30 years in the civil status of lesbian, gay, bisexual, transgendered Americans all over the country, including Virginia, where it is no longer a crime to engage in consensual sodomy, not thanks to the Virginia legislature, but thanks to the Lawrence opinion by the Supreme Court. Ironically, well before the Lawrence opinion, which was only in 2003, well before that, and indeed in the wake of Bowers and Hardwick, which you might have read in con law as well, that was the overruled opinion in Lawrence. Bowers and Hardwick said, yes, you can make consensual homosexual sodomy a felony, which in Georgia was a mandatory sentence of 1 year up to 20 years for consensual private intimacy. The Supreme Court said that was fine, raised no constitutional problems. Yet in the wake of Bowers and Hardwick, Denmark in 1989 recognized lesbian and gay partnerships, what they called registered partnerships, with almost all the same benefits and legal obligations of marriage. I was a professor at Georgetown at that point. No one in the United States really saw the Danish statute coming. It was a huge surprise, even to gays and lesbians in the United States, that a country, through its legislative process, would recognize lesbian and gay relationships basically the same as marriage, though not the term. I was the attorney in the first lawsuit after Denmark by Patrick Gill and Craig Dean, the latter an alumnus of the Georgetown Law Center. Filed a lawsuit, and I became their attorney through Gay Law, an organization that I was part of in Washington, D.C. Like the Hawaii lawsuit that closely followed that, the D.C. lawsuit was unsuccessful. But it has opened a period of about 20 years now where lesbian and gay couples have been marching into court and sometimes into legislatures seeking recognition of their relationships as marriages, although often as something euphemistically different from marriages, civil unions, domestic partnerships, and so on. And I'll talk about the arguments when I get to the Olson and Boyes lawsuit, because the arguments have been almost exactly the same on the gay and lesbian side for 20 years, and they have been highly mobile on the other side for almost 20 years. Suffice it to say that during your lifetime, there has been a sea change in recognition. Massachusetts was the first in this country, Netherlands was the first in the world in the modern era to recognize same-sex marriages. There are now, I believe, 5 states, 4 in New England and Iowa, that recognize same-sex marriages in their jurisdictions. There are recognitions of virtual equivalents to same-sex marriages in New Jersey, which has civil unions, in California, which calls them domestic partnerships, in Nevada, which calls them domestic partnerships, available, by the way, also to different sex couples as well as same sex, in Oregon, which calls them domestic partnerships. And then in D.C. as well now, though that has not gone into effect yet, there is partial recognition of same-sex relationships with not all of the benefits and obligations of marriage, but many of them. In Maine, which recently overrode its marriage statute by a popular vote, calls it domestic partnership still. They have that still. In Hawaii, which calls it reciprocal beneficiaries. And in Washington, which has a domestic partnership statute, which is well short of the California one, and which was recently sustained on popular vote. So there are a number of states, and a growing number of states, that have formal recognition at the state level. Now, as you probably know, most states not only do not have formal recognition, but more than 40 states have either statutes or increasingly constitutional amendments which say that their state affirmatively does not recognize same-sex marriages, either within the state or coming in outside the state from, say, Massachusetts and so on. Now, in New York, they don't give out marriage licenses, but the New York governor and the New York courts will recognize same-sex marriages from Massachusetts, Connecticut, New Hampshire, and Vermont, and other places as well, probably Canada, that has the institution too. And then the final piece of the puzzle is that in 1996, Senator Robert Dole, the majority leader, House Speaker Newt Gingrich, and President William Jefferson Clinton delivered to America the Defense of Marriage Act, which means, among other things, that the more than 1,100 federal statutory provisions and regulations that use the term marriage or spouse or spousehood will never recognize same-sex couples, even if all 50 states recognize same-sex marriages. So the irony is that even as America has been increasingly recognizing same-sex marriages or other relationships, at the federal level it's been relatively stable. And of course the deeper irony is that this stability, the most ambitious anti-gay and lesbian statute in American history, and a statute protecting marriage, was delivered to you by the nation's highest-ranking adulterers, namely Robert Dole, adulterer, Newt Gingrich, adulterer, and William Clinton, adulterer. Bipartisan misbehavior. Right? But protecting marriage, not protecting their own marriages, but protecting the marriage of maybe you all and other Americans. So that's the lay of the land. As you probably know, if I'd been giving this talk last year, I would have had also in the same-sex marriage camp Maine and California. Because California Supreme Court in 2008, by a 4-3 vote, an opinion by Ron George, the Chief Justice, and a Republican, conservative Republican, struck down the California statutory and popular prohibition of same-sex marriages as inconsistent with the California Constitution. Now that ruling was overridden, as is possible under the California direct democracy provisions, by a popularly initiated constitutional amendment. That's the famous Prop 8, right? And the voters, by about, I believe, 52% to 48%, more or less, voted in favor of amending the California Constitution to limit marriage, both licenses and recognition, to one man and one woman, and therefore nullifying the possibility of same-sex marriage. The California Supreme Court in the Strauss litigation recently upheld that constitutional amendment, but interpreted the amendment not to be retroactive. So there are about 17 or 18,000 same-sex marriages in California entered between June of 2008 and November of 2008, when the repeal took effect, that the California Supreme Court says are valid marriages in the state of California and have survived Proposition 8. So that's the lay of the land. The Olson and Boyes lawsuit is a federal constitutional challenge, because all of the California litigation, both the original litigation and the Prop 8 litigation, were pursuant to the California Constitution, not the U.S. Constitution. Now, why is that, you might ask? Why not obviously make the federal constitutional arguments? And the answer is they did not want the California Supreme Court to issue an opinion in either case striking down same-sex marriage bars based upon the federal Constitution, even though I think there are excellent federal constitutional arguments, because that would all but invite or maybe even require the U.S. Supreme Court to take review and reverse them. And the conventional wisdom, which I share, is that there are not 5 votes in the U.S. Supreme Court to force same-sex marriage, not onto California. There might be 5 justices who'd be perfectly happy to have same-sex marriage in California. But any kind of federal ruling would also probably force it on Mississippi as well, and Virginia, and other states that would be even less willing than California was. Now, Ted Olson, as you surely know, is probably the most preeminent conservative Republican advocate and lawyer in the modern United States. He was the Solicitor General under Bush 43. He was the winner in Bush versus Gore. The country was the loser, maybe. And indeed, the attorney he defeated in Bush versus Gore was Boies, his same-sex partner in the Olson Boies lawsuit that has been brought now, the Perry case, in California, in federal district court, before Judge Vaughn Walker, challenging the federal constitutionality of Prop 8. Okay? So this is the challenge. And the arguments that they are making, in my opinion, they need to be clearer about exactly what they're arguing. But the main argument they're making, the main argument that is the basis of the evidence, is that there is a fundamental right to marry under the federal Constitution. This has been recognized not just in Loving versus Virginia, good, our state, right, Loving versus Virginia, squalid law, good court decision, which said that it was not only an unconstitutional race discrimination for Virginia to bar different race marriages, but the alternative holding of Loving versus Virginia was that there is a fundamental right to marry. This was not much elaborated. A fundamental right to marry, and that the Virginia bar also violated the fundamental right to marry without sufficient justification. There have been subsequent federal Supreme Court decisions. One of them, I'll only mention one of them, Turner versus Safely, where convicted prisoners, in other words, murderers, rapists, and the like, in Missouri, challenged that state's bar to marriages by people who were incarcerated. And the U.S. Supreme Court, with no recorded dissent, though I will say that Justice Scalia did not record a vote on this issue, which is very unusual, but in a majority opinion by Justice O'Connor, ruled that this also violated the right to marry for the state to absolutely bar prison inmates from marrying. And she talks about even for inmates who have life sentences and no connubial visits, there are many moral, spiritual, and economic benefits and obligations that go with the marital relationship. And so here's another irony, and that is that in most of the United States today, and under President Clinton's Defense of Marriage Act, there is a constitutional right for convicted murderers and rapists to get married, but not a constitutional right for lesbian couples who are committed to one another, exemplary citizens, and raising children in a loving relationship to be married. And that is a severe incongruity, irony, and even hypocrisy in the United States. So their first point is the fundamental right to marriage is a fundamental civil right, which is accorded very broadly to consenting adults, and certainly the most saving group that is omitted from this in current positive law is lesbian and gay couples, including in the state of California. Their second argument is that this denial of a fundamental civil right imposes grievous harms upon same-sex couples, such as the couples who are the plaintiffs in the lawsuit. And then the third argument they're making is that the state and the defenders of Prop 8 have no good reason for denying these couples this kind of right. And indeed, they're arguing that the main justification and a lot of the campaign by the defenders of Prop 8 were open appeals to bigotry and prejudice. In particular, and this I'm thinking about some of the evidence they've actually introduced and not just their arguments. In particular, they claim that much of the campaign in favor of Prop 8 was an appeal to the stereotype founded upon deep prejudice against gay men, based upon the allegation that gay men are child molesters. It's a traditional trope in American history. In the 1950s through the 1970s, it was a trope that was aggressively endorsed by the state. It was never based upon any kind of factual foundation. It was always, in my opinion, an untruth about gay men, and didn't even pretend to be a truth about lesbians, who are the least predatory social group in America. Okay, and that's they make the argument. The Olsen boys witnesses make the argument that this is based upon animus and prejudice against gay people. But they also make the argument that there's no positive justification that the defenders of traditional marriage have been able to advance. And then they've introduced witnesses on those various claims. We don't exactly know what the witnesses are going to say for the defenders of Prop 8 because they're just now taking up their case. What I think they'll say will be something along the following lines. The first thing they will certainly say is that, yes, they will agree there's a fundamental right to marry, and they might even agree that it's a fundamental civil right. I think they should agree with that. But they will argue that that's a fundamental right to traditional marriage. And they will maintain that not only is gay marriage an oxymoron, because marriage is fundamentally about the possibility of procreation between a husband and a wife. In other words, marriage itself is a category that is fundamentally gendered in a way that is ignored by the plaintiffs. Marriage has got to be about one man and one woman. Now, I think if they are intelligent, they will also make the argument, we talked about this at the faculty workshop, I think very productively, the argument they should be making is that marriage, the reason it's fundamental, this is the smart argument, you might not want to hear this, but this is the argument, that one reason marriage is fundamental to American civic as well as personal life is that marriage rests upon three normative foundations, and they're interconnected. One is religious. Most of the world's major religions, and certainly the Judeo-Christian religions that have dominated the United States, believe that God is connected with marriage. When you get married in a religious ceremony with rabbi, priest, minister, etc., that God is one of the participants and that this is a sacramental institution before God, and part of the marriage contract is not just the couple's relationship with God, but the couple's relationship with the congregation and the other religious faithful. So one prong is the religious history of marriage. Another prong is the cultural tradition of marriage. So in the United States, much of what we celebrate as marriage does not have a distinctive religious connection. The fact that you have the wearing the fancy clothing, that you have the wonderful music, that you have all your friends there, and they give you lots of gifts. I mean, none of this is in the Bible, I will tell you. I have officiated at 3 marriage ceremonies, and I guarantee you none of this is in the Bible. But this is all very important. The participation of family, the ceremonies that I participate in, I won't do the father of the bride gives away the bride. I think that's patriarchal and property-oriented. But what I do when I preside over marriage, I mean, I'm not kidding, this is a great idea, I think, so if you ever do this, I would urge it upon you, is that I have both partners, whether groom and groom, bride and bride, bride and groom. I've done 2 different sex marriages, 1 same-sex marriage. What I ask the couple to do is each of them expresses what they're most grateful to their parents and their loved ones who brought them to this day. Not to give them away, but who brought them to this day. And the parents or whoever will stand up and receive the thanks from their progeny or whoever it is, which I think is a new tradition and I think a great way to do it. So this is the same thing, is the cultural stuff. that marriage has enormous cultural resonance in the United States. And then the third is legal. As it's law students, most of you law students, marriage entails thousands, when you put state and federal together, more than 1,000, legal rights, benefits, obligations, and duties. Many of them very routine, simple decision-making rules. That if you have a spouse, she or he is the default decision-maker along lots of dimensions, some of which you can change by contract or by documents. You have obligations, you have support obligations, you have fidelity obligations, etc., etc. So there's a lot of legal connection as well. And in my opinion, the traditionalist's best argument is that one of the reasons marriage is very foundational to American society is that it rests upon all three of these legs together. In other words, the religious, the cultural, and the legal all combine together to give marriage its unique place. And their argument should be that if you take away the religious, traditionally one man and one woman religion, if you take away the religious, then this is their argument that this is essential to marriage and this will weaken marriage if you take away that leg. Now, I don't think that's what will happen to marriage, but I think that's their serious argument. So I think that will be the main point of contention. I think it will really be overwhelmingly that number one thing. I think there'll be agreement that marriage is a fundamental civil right, etc., but there'll be huge disagreement, deep disagreement, as to what that fundamental civil right is and how you define it. I'm sure the defenders of Prop 8 will disagree that the denial of marriage rights in California imposes grievous harm on the plaintiffs. And their argument will be very simple. Their argument will be, look, the plaintiffs in their own community get lots of support, and the state has afforded domestic partnership, which gives the benefits and obligations of marriage, including for children. So my sister and her partner are domestic partnered in California. My sister has 2 children. Because her partner Lois, same-sex partner, is legally her domestic partner, Lois has all of the same parental rights that Betsy does. And this is important to the children. It's important to Betsy and Lois. The state already provides that through the domestic partnership law. So the plaintiffs will, or the defendants will argue, the defenders will certainly argue, that California is the worst place to bring this sort of lawsuit because there's not grievous harm. In fact, there's no legal harm, they would argue. It's at most a dignitary harm. And then they would further maintain it's a dignitary harm to traditionalists to have same-sex marriage recognized. So their argument would be there would be a dignitary harm on either side. And in those kinds of situations, this is exactly where you should leave it to the legislative process, or in California, maybe more accurately, the popular process. And then thirdly, they will argue that there are, apart from the first 2 kinds of arguments, they would argue that there are sufficient reasons to limit marriage to one man and one woman. And I think their main argument, in addition to what I've already said, probably is, and I think this is not a very good argument, but I think their main argument is that marriage being all about procreation and fundamentally about, or maybe not exclusively about, raising children in a committed relationship, they would argue that the legislature and the people can rationally believe, not you have to believe it, but there's room for disagreement, and the people could rationally believe that you can prefer traditional one-man, one-woman marriage as a situs for raising children to same-sex marriage as a situs for raising children, etc. Now that's the way I see it. Now here, I'll just say a few words of critique and then open it up to expressions of astonishment, etc., from you all. The main criticism I would make of the Olsen boys' side, in other words, the challengers, is that this is a dangerous lawsuit. It's overwhelmingly premature, this lawsuit. There is no chance that a majority of the current U.S. Supreme Court would sustain their claims. Even though I personally think that it does violate the fundamental right to marry of the Constitution. And moreover, I would also say, which I think they will say as well, this is a use of either a sex discrimination or sexual orientation discrimination required heightened scrutiny as well under that prong. Though that's not their main argument in these testimonies. So I made this argument. These are exactly the arguments I made in 1996 in the case for same-sex marriage. But this is not an argument. Not only will there not be 5 justices, I don't even think there would be 2 justices, and maybe not even 1 justice, who would be willing to cast a vote to say, as a matter of federal constitutional necessity, the states have got to recognize same-sex marriage. Now, would they be willing to do 5 years from now? Well, you can't really answer that because you don't exactly know who will be on the court 5 years from now. But I think it's also very doubtful 5 years from now. I think it's quite possible 5 years from now California voters will go the other way on Prop 8, though who knows. But it's only quite possible. It seems likely that this will appear back on the ballot in California as early as 2012. And it is certainly quite possible, given the narrow margin of defeat last time, that the margin might be reversed next time, though that's not inevitable. Thematically, the reason I think that even the more moderate justices will be reluctant to impose same-sex marriage on Mississippi is that the Olson boys' lawsuit, and maybe this is why it's so significant that Ted Olson is the plaintiff's lawyer, is that conservative Republicans have so far been unable to close the conversation through a federal marriage amendment. That was the Bush administration's agenda. But that means, correlatively, that the conversation should not be closed on the other end as well. Because America, the truth is intensely but evenly divided on this issue. Here's the way I see the division, and I think this will continue to be the division for a while. On the one side, you have a minority of Americans who favor same-sex marriage, often for identity-type reasons, gays and lesbians often, but also their parents, close friends, gay-friendly straight people. But increasing support, for gay marriage, by the way, the key support is people like Olson, who's openly heterosexual. He's had like a whole boatload of wives. I don't think I have enough fingers for the number of wives he's had. He's openly heterosexual, tons of wives, satisfied customers, etc. And so he, increasingly, the supporters of same-sex marriage are open heterosexuals, people who are credits to their sexual orientation, but who support gay rights, including same-sex marriage. Okay? And they believe it intensely. I mean, Ted Olson, there is no doubt in my mind. I know Ted Olson. He has devoutly, always, for a long time, been in favor of same-sex marriage. And he thinks this is really important. This is not any kind of like lavender herring or any kind of Trojan horse. On the other hand, you have a big chunk of America that devoutly, literally, believes that same-sex marriage is extremely bad. That for religious, particular reasons, but sometimes not just religious reasons. They think this is abominable, that this is sinful, it's bad for America, Armageddon, some of them believe Armageddon, etc. And then you have a big middle group of Americans who believe that there should be some legal institution for these decision-making things and obligations and the children thing, maybe even, but who don't necessarily believe that it has to be called marriage. Maybe for this reason that I've articulated. The connection, marriage, the religious, cultural, and legal thing that the term marriage all combines within it. Now that's exactly a situation where the conversation should not end, where the population is evenly but intensely divided. Because whoever loses, whether under the Bush administration, lesbian and gay couples lose, or under the Olson boys thing, the opponents lose. It is sure to create bitterness, and whether this is the courts or the legislatures, I don't think it makes a difference that it's the court. It is certain to create bitterness. It probably would create violence for one side to unequivocally win and one side to unequivocally lose. At a stage where the polity is genuinely, and I think it's wrong to believe, I think it's wrong for traditionalists to believe that the people supporting same-sex marriage are sexual zealots who believe in political correctness and who hate religion. And I think it's equally wrong for progressives to believe that the people opposing same-sex marriage are just foaming at the mouth bigots, the sort of modern equivalent to George Wallace, et cetera, et cetera. I think these are simplistic ideas. I think they're inhumane ideas. I think they're also incorrect ideas. So that's my main criticism of the Olson-Boyce lawsuit, that it is clearly premature. The way to go, it seems to me, is still state-by-state debate. And then see what happens. Massachusetts had same-sex marriage since 1994, or 2003, 2004. Well, has it hurt marriage? Are the couples doing fine? What's been the experience in Massachusetts? I think it's been fine. Canada has had it about a little bit less long, about the same amount of time. What's happened to marriage in Canada? It's done fine. Conservative Canadians do not seem eager to revoke same-sex marriage. It's not sort of fallen lower on their agenda. So I think this is useful information, but I think it's not definitive information. And so let's see how Iowa does, et cetera, et cetera, et cetera. So that's my criticism of that side. My criticism of the other side, I'm not exactly sure what they're going to do, so I'll withhold most criticism. But I do think the other side is going to run into a danger of the accusation that their case will be so unfactual that it will seem like nothing more than the implication of traditional anti-gay stereotypes. So by raising the lesbians, raising children is dangerous to America. If they want to run that line of argument, I think it's a very dangerous line for them to run if they don't run it in exactly the right way. And so we'll have to see what their witnesses say. I think they really have to make the definition of marriage argument in a more sophisticated way than you usually see from opponents to same-sex marriage, because it sounds so much like the opposition to miscegenation or different race marriage. If you make it, well, it's always been this way, and God wants it this way, et cetera, et cetera. Those are exactly the arguments that were used against different race marriage. And so you have to come up with something much better. And then for them to fall back on arguments, well, race, is just different from sexual orientation. That's also not a good response, though it's one that we will probably hear. Now, one final thing, and then I would love to have questions, and that is, here's the upside of the lawsuit. So I've been very negative, like they shouldn't win. They're not going to win, and thank God they're not. But here's the good thing about it, from my point of view, and I support same-sex marriage, et cetera, et cetera. The good thing about it is that almost any discourse about same-sex marriage at this point in our history is going to be good, in my opinion. For same-sex marriage, by the way, for same-sex marriage. Particularly if it doesn't result in the Supreme Court decision imposing it on Mississippi. Because in a trial, I think the trial is very clunky. I think most of the witnesses have just uttered nonsense. The cross-examination has been kind of odd. It doesn't work very well. But it's a nice theatrical moment. Somewhat akin to Gavin Newsom's handing out marriage licenses like lollipops at the dentist's office. It was unlawful what he did. California Supreme Court nullified it. They probably should have. I think they should have. But should he have not handed out marriage licenses? No. I think it was kind of okay. Gavin Newsom said, look, I think as a matter of my interpretation of the Constitution, I think these folks should have marriage licenses. I think they're entitled to marriage licenses. And I do too, personally. And so you had this outpouring. And the more events that you have like this, the key thing is not these idiotic witnesses, because most of these witnesses are just beyond caricature, some of them. But the best people are the actual couples. Give some publicity to these couples. A lot of Americans 10 years ago believed that same-sex marriage was just some political correctness stunt. It was kind of a joke. It was not serious. And they just didn't associate lesbian and gay couples with long-term committed relationships raising children. Well, a lot fewer Americans think that way today, because it's really pretty much beyond dispute if you're paying any attention, which of course not everybody is, and they don't have to, that there are lots and lots of committed couples, same-sex couples, a lot of them raising children. This is now documented by the U.S. Census. You don't need expert witnesses on it. It's in the census. I think the last statistics I heard, about a third of the female couples cohabiting together in the census were raising children in the household, about a fifth, I believe, of the male couples. And other statistical things have found also very significant numbers. This is a serious phenomenon. And it's also the case that lesbian and gay couples want to get married or unioned, or whatever term you're going to use, for very similar reasons, I think pretty much the same reasons, as different sex couples. And it has very little to do with the legal stuff. With, we want, the goodies. We want Social Security goodies, or we want those legal default rules. I don't believe that those are major motivations. And you don't either. The major motivations are that we're committed to one another. We're in love with one another. Very often we want to have children with one another, or even already do, or want to adopt, or something like that. And we want to have a public acknowledgement of this, because marriage is a big public event. Remember the three prongs? It's not just trotting down to the state and getting the marriage license from the marriage license bureaucracy, but it's having a religious ceremony, and a lot of the same-sex marriages are in religious ceremonies with real priests, real rabbis, and real ministers, which I am not. So the ones that have me are not getting any of those things. Not a rabbi, not a priest, not a minister, but often an officiant. But they're getting real rabbis and real priests and real ministers in real churches. And then they've got their friends, their families, etc., who are a faith community and a family community who are making a commitment, we're going to support this family. And I think, and of course the presents are also good. I think that's also a motivator. And the choreography of the wedding dress and the Prince Charming and all of the other schmaltzy Walt Disney romantic choreography that is America, I think also motivates people. Okay? And then a lot of the couples that I've interviewed over the years are already raising children, and a lot of them do it for the children. They do it for the children. And sometimes the children are shocked when they learn, you're not already married? They just say, of course you're married. No, we can't get married. The state won't give us a license. The children say, we've got to get married. Sometimes the children will say that, which is quite often. So the more this is talked about, the more the positive case, I think, emerges in human terms. Because the positive case has always been the same, that these are serious couples, blah, blah, blah. The negative case keeps changing. At one point it was the definition of marriage. Then it was defensive marriage, the Clinton thing. You got these adulterers saying, I have to defend marriage. It says, the Pillsbury Doe adulterer, President Clinton. That argument has not had a great history. Then you get the can't raise children argument, or variations of it, etc., etc. It's a cause still in search of an argument. Now, I think I have their best argument. I've just given it to you. And they might never find that argument. So send them an email if you want them to find that argument. So my view is that this will, in many ways, advance the cause of same-sex marriage, particularly if we lose. I think it advances it more if we lose. At some level, Supreme Court level, maybe Judge Walker, Ninth Circuit, et cetera, et cetera. Because keep in mind, Bowers and Hardwick was one of the great victories for the gay and lesbian rights movement. It galvanized people in ways that a win in Bowers would not have galvanized. Win in Bowers would have galvanized Judge Bork. We would have Justice Bork today, in my opinion, if we had won Bowers and Hardwick. Because Judge Bork's testimony for the Senate would not have been his goofy take on Griswold versus Connecticut. Griswold, bad decision. But Judge Bork then protects married people against the state saying they can't use contraceptives. It's very unlawful. So would you say the state could do it? Sure they could do it. If it's not in the Constitution, sure they can do it. Wow, Judge Bork. But if Bowers and Hardwick had come out the other way, Judge Bork would not have gone after Griswold, which was the nuttiest thing to go after in the history of Supreme Court confirmation hearings. That was nutso. Instead, he would have gone after Bowers and Hardwick. these liberals on the court, Sodom and Gomorrah is what they're bringing. Remember, Bork was nominated at the height of the AIDS epidemic. Bork would have said, constitutional right to engage in sodomy? You know what sodomy is? He said, I'd rather not hear. Well, sodomy is anal sex, and that's what leads to AIDS. That's the Supreme Court's corrective. You think the American people would have turned against Judge Bork in 1987 if he were in the closet about contraception? The short answer is no. And the long answer is not at all. So we would have had Justice Bork, I think. You know, et cetera, et cetera. Okay, I'll close with that, which is far afield from the Perry case. But it's one of my favorite little talking points. Kelly, you're in charge.
Okay. We can start with questions if anyone has one. If people don't, I've got a couple.
You can make speeches.
My question is, how do you respond to the argument that allowing this issue to proceed through the popular vote only reinforces the idea that a majority can choose when to give rights that should be inherent or fundamental to a minority?
Well, here's a realistic way of responding. Okay, so one way you can say is, sure, there's certain rights that ought to be beyond the majoritarian process. But is marriage one of them? And part of the answer is it certainly never has been in the United States. Marriage has never been beyond the majoritarian process in the United States. And here's Exhibit A for it. Anti-miscegenation laws. You know, in 1954, Brown versus Board of Education started a judicial campaign against racial segregation in public schools. It didn't end the campaign, but it was a serious start. At the very point when Brown was handed down, there was an appeal from the Virginia Supreme Court in Name versus Name, N-A-I-M, which was the Virginia white supremacy law. Not what it was called, but that was the justification. Dilution of the white race laws, the anti-miscegenation law, I believe adopted in 1923 here in the state of Virginia, or Commonwealth Virginia. Supreme Court, which is their typical response, vacate and remand for the Virginia Supreme Court to reconsider in light of Brown. Virginia Supreme Court reconsiders in about 5 seconds, reaffirms its original decision. You know, this is Virginia. Brown is about schools. This is about marriage. And they write, an opinion reaffirming. Goes back up to the U.S. Supreme Court. This is inconsistent with Brown. The U.S. Supreme Court rejects the appeal in like 56, 57. Sends it, Virginia Supreme Court gets away with it. They get away with an open defiance of the anti-segregation mandate. But they did it when 30 states in the United States, so it was not just Virginia, it was 30 states in the United States. A lot of northern and western states, as well as the southern states, had laws that prohibited different race marriage. And the conclusion is virtually inescapable that what the Supreme Court was doing was you can use the word bowing or acquiescing or kowtowing or weaseling, whatever word you want to use. They were deferring to majority sentiments. Now, the way I would put it is they were deferring to the fact that different race marriage was a normative conversation that America had not concluded. A big chunk of Americans believed that people ought to be able to marry someone of a different race. Another big chunk of Americans, including Northerners, not just Virginians, believed that violated God's word. Most of the arguments were religious arguments, that it was an abomination, that it was not acceptable, and they believed in this very. And then there was a middle group that probably was on the whole against different race marriage, that didn't feel as strongly. It's the same kind of conversation. America was intensely but evenly divided, and maybe a little bit more on the anti-side in 1954. Intensely but evenly divided. And for the Supreme Court to call an end to that conversation would have invited not just disrespect, but open rebellion against the court and probably against the civil rights revolution itself. And so that's what the court did. Now, fast forward to 1963. Case came back, the Loving versus Virginia case. Mildred Jeter and Richard Loving here in Virginia. They were married in D.C., total legal. They came to Virginia. Virginia arrested them. They were legally married in D.C. So it's not like Virginia said, we're not going to arrest them. No, we're going to arrest you. It was a crime for you to be a married, different race couple and be in Virginia. Be in Virginia. So the Lovings challenge it. Of course, they hightail it back to D.C., but they challenge it. And Judge Brazil, local judge, in 1963 ruled the different race marriage law is constitutional. And he relied on the Bible, that God has decreed the separation of the races, and this is God's natural order, constitutional. It was 63. It goes up to the Virginia Supreme Court, and in the interim, we have the March on Washington, the 64 election, the 64 Civil Rights Act, we have the Voting Rights Act of 65, etc. And also in the interim, by the time it gets to Virginia Supreme Court, most states have repealed their miscegenation statutes. By the time you get to 67, there were 16 states, including Virginia, I think. So a total of 16 states by 67. Then 30 before that, 16 by 1967. So all outside of Virginia. It's all in the South. And even in Virginia in 1966, one other thing Judge Brazil did, which I think is just bizarre, he also said, okay, we're going to sentence you to jail, you Lovings, but we'll suspend it if you agree to stay out of the state for 25 years. Now, how bizarre is that? So you've got religion, natural law, and bizarro Superman, all in the same case. So it goes up to Virginia Supreme Court in 66, and they issue an opinion affirming, so we're going to uphold it. No Bible, no God, but just say, well, we've already decided this in name versus name. We follow a precedent in Virginia, end of case. And then they vacated this weird 25-year thing. No, we're not going to prohibit you from traveling in the state for 25 years. We're just going to vacate that. 66. And then in 67, it goes to the U.S. Supreme Court, which unanimously strikes it down. Now, these are virtually the same people who had ducked the case in 56, 57. But what had changed was not the people on the court, nor their realization that racism, the statute was called white supremacy. It was a white supremacy statute. That was what Virginia argued. White supremacy was in the statute. So it was not like this was in the closet. So the justification was the same. The justices were pretty much the same. And the justifications were just as squalid, and they knew that. What had changed was public sentiment. Now, there were still a lot of people who didn't like different race marriage. But there were fewer of them, and they didn't believe it nearly as intensely, outside the South particularly. South, much more intensely. And the Supreme Court at that point struck it down. And there was a lot of criticism in the South, but there was not a huge popular revolt against the Supreme Court's doing that. So here's my point. It's a larger con law point. That it is not correct descriptively to believe that rights are exogenous to the majoritarian and political process. It's not correct to believe that. So you might have been taught, or you might have read books that say this, that the Constitution provides special protection, equal protection to discrete and insular minorities who are victims of the political process. Actually, the Equal Protection Clause is almost the inverse of that. Is that when African Americans really were totally politically powerless, the Supreme Court did very little for them outside of providing some criminal protections and some voting protections at one point. But no equal protection stuff. No equal protection stuff. That was the Plessy regime. It's only after African Americans actually start gaining some political traction, mainly in the North, but also in states like North Carolina, Virginia, in the 50s, that you actually see the Supreme Court coming in. And the court usually follows Congress. They didn't really come in a bigger way until after the 64 Act, and then after the 65 Act. You see a little more aggression on the part of the court. Women, when women couldn't vote, which is almost definitional of political powerlessness, blacks couldn't vote either in Virginia. When women couldn't vote, the Supreme Court did zilcho for them. Zilcho. I believe the first time the Supreme Court struck down on constitutional grounds an open sex discriminatory statute, and there were thousands of them in American history, was in 1970-71 with the Reed case. And that was on the eve of the Equal Rights Amendment, where Congress by 2/3 majority. Okay, that's not. That's the majority process. And gays and lesbians, the same thing. Gays and lesbians, the same thing. Is that when gays and lesbians hovered in the closet, outlaws in every jurisdiction in the United States, i.e. in the 50s, outlaws, criminals, not only did the Supreme Court do nothing for gays and lesbians, but the Warren Court, which you might have been led to believe was a very progressive court, and it was in some ways, but it was the most anti-gay court in American history. Their big gay case was Boutier versus INS in 1967, where there was an immigration statute that said, we're not going to allow as immigrants in this country anybody who is afflicted with psychopathic personality. And the INS applied it to a bisexual Canadian, Mr. Boutier, and the record reflected that he had had relations with women, he had had relations with men. The record did reflect that it was a fact that he had a life partner in New York State when he was arrested. And then ultimately, the INS people deported him back to Canada, based upon their finding that because he was what they thought was a homosexual, today we might say maybe a bisexual, because the record was he had sex with women and with men. That does not sound like a homosexual to me. So they translate possibly bisexual to homosexual. Bisexual equals homosexual. And then homosexual equals psychopathic personality. And the Warren Court affirms. Earl Warren, majority. Hugo Black in the majority. Tom Clark writing the opinion for the court. Right? So they not only rejected the constitutional argument, there was a void for vagueness argument, but they also interpret the most open-ended, imaginable statute. What on earth does it even mean to be afflicted with psychopathic personality? I have no idea to this day what it means. Some of us have used the term for the most recent president, President Bush 43. Others would use the term for President 44, maybe, right? But that would be political overkill or facetiousness. I don't even know what a psychopathic personality is. I have some colleagues that I would say maybe, but again, I think that would again be facetiousness or just viciousness along those lines. So the most spongy possible term, they interpreted the most aggressive possible way to demonize a gay person who was hurting nobody and who had a life partner in the United States. He was deported. It broke his heart. He tried to commit suicide. He died in the most unhappy circumstances, a victim of the Warren Court's homophobia. Okay, you see the point. That it's not like the court never protects the unpopular, but not under the Equal Protection Clause they don't.
Do you think it's more important that it's a popular majority, most American people, or that most states have passed legislation?
Well, there's usually some correlation. The state legislation can be correlated with either most people are okay with X, or most people don't care, and so the intensity of the issues go away. And I think on the different race marriage issue, like I think Wyoming was one of the states. It's hard for me to imagine that the people in Wyoming were paying lots of attention to this issue. But the Wyoming legislature was like, you've got this civil rights thing going on, and look at what these horrible people are doing in the South. You had these racist governors, slobbering and defying, I'm not going to let, and then they used nasty words. People in Wyoming were like, we don't want to be like those people. They said, well, we have a miscegenation law. Where'd that come from? And so they sort of scooted out the door. And the people in Wyoming are probably not paying very close attention. So a lot of it is that it reflects the thoughtful, deliberative process is sort of turning against it, and the people are sort of either going along or maybe even positively supportive. So sometimes it's just fudging the idea of majoritarianism. But my basic proposition, which I will immediately concede is not original with me, my colleague at Yale, Robert Dahl, the great political scientist, this is his proposition. And he announced it in the 1950s. and again I'll repeat it, that an issue that evenly but intensely divides Americans is one where a healthy democracy does not want to close the conversation. And perhaps the worst way to try to close it is through a judicial decision. But even the legislature shouldn't do it. Yes, sir.
I just had a quick question. I have to leave in a couple minutes, but
you won't just pop up and leave, and I won't offend you.
You talked about how, especially in California, the legal rights of marriage is not really what's at issue here, because those seem to be available through other means.
Absolutely.
It's about access to the institution, you kind of breezed over this, or being able to define oneself as being married.
Right.
So it's really kind of about the definition of marriage. And I'm just curious, as this progresses, as you see it progressing, that it will liberalize, do you think that will have an effect on other institutions that have been locked out of marriage, like polygamy or things like that? What kind of effect do you see this having down the road? Is it a blurring that will eventually become where anyone can define marriage in whatever way they want?
Well, by the way, that's the status quo. The status quo is anyone can define marriage the way they want, because that's the battle. The battle is the linguistic battle. And then again, that's why I think my side is winning. I think we're winning the linguistic battle. 20 years ago, you would never see in a law review, almost never see in a law review, or the New York Times, the word marriage used for same-sex couples. The word just wouldn't even be used. Then you would start seeing so-called homosexual, quote-unquote, marriage, in law reviews, in the New York Times, etc. Then you would start seeing, and this is more like y'all's lifetime, then you would start seeing things like same-sex marriage, maybe without quote marks, or gay marriage, maybe without quote marks. And now you're seeing marriage equality. That's the revolution. The revolution has already occurred. The linguistic revolution. Okay? And indeed, I think, and you think too, that if a lesbian couple in Virginia, and I've married a couple in Virginia, outside of Charlottesville, let's say a different sex couple, but let's say they were a same-sex couple, okay? I married Nicole and John, but let's say they were Nicole and Kim, female Kim. That would be a marriage. It would be a marriage. There were a faith community in attendance, their family in attendance, witnesses, their community. That would be a marriage. They would call it a marriage. They would consider themselves married. Other people probably even Governor McDonald would consider them married. He wouldn't say it was legal marriage, but they would be called married. They'd be called married, even in Virginia, which is a very conservative state, in my opinion. And that's most of the battle. Now, what I think it's about in California, and what witnesses on the challenger's side have been testifying, is that it's demeaning, it's a dignitary affront. This is what the claim is. Now, here's what would make it a better claim, by the way. I don't think they've done a very good job, and they're making a dignitary claim. That, and I presume, I haven't seen this in the witness's testimony, but I assume it's somehow come up. Let's say after Loving versus Virginia, Supreme Court reverses Virginia white supremacy miscegenation law out. Let's say Virginia then comes back after Loving and says, we're going to create a new institution for different race couples. We're going to call it civil unions. We'll have marriage for same-race couples and civil unions for different race couples. Now, put aside the obvious issue that would be a race discrimination, which was the main holding of Loving. So throw that out. What about the fundamental rights to marry holding of Loving? Would that be affronted by a civil union statute? Well, I think the answer to that is yes in 1967, but not for any legal reason. It would be because in 1967, there was a national consensus that the court wanted to confirm and seal that you simply cannot treat couples differently based upon their race, even if it's only terminological. Okay? Now, we're not nearly there yet on same-sex marriage. Because remember, the different race marriage campaign was decades, and it followed a very intense campaign for anti-discrimination and desegregation on all these other fronts. The same-sex marriage thing, oddly enough, even before Lawrence was done, it was still a crime in Virginia. It was a felony in Virginia to engage in consensual intimacy, right? And the same-sex marriage thing was taking off 2003, when Massachusetts did same-sex marriage. Right before that had been Lawrence. So the very same year, it was a crime in Virginia and about 16 other states, or 13 other states. It was a crime in Virginia, but you were getting same-sex marriage in Massachusetts, right? So there is it's much more hurried in the gay liberation stuff. And that's not going to work. That's not going to work. It needs to slow down just a bit and proceed state by state, in my opinion. So I think that's the way it's going on. I know he's left, but maybe some of the rest of you are interested in hearing about all of that. Yes, ma'am.
So I'm interested in the fundamental right to marry. Suppose that there was a state that just said, look, we're not going to perform legal marriages anymore.
Yeah.
You want a private commitment ceremony, get married in your religion, that's completely fine, but no more marriage here. We're not going to treat married couples and unmarried couples, same-sex or opposite sex, differently in this state. Would that violate the residents' fundamental right to marriage, a federal constitutional right?
Excellent question. And let me relate it to the polygamy question. Okay. The answer is I don't think so. Because let me distinguish three cases. Loving seemed to say the fundamental right was a due process right. Remember, this is state, so equal protection clause and process clause. The next case that I didn't mention was Zablocki versus Red Hale. That was the deadbeat dads case. Wisconsin said deadbeat dads cannot remarry. And they struck it down. By the way, that's actually I like that justification. I don't see that as like a really terrible law. But the Supreme Court, Thurgood Marshall wrote the opinion, and he wrote it as an equal protection test. He said, this denies equal protection to deadbeat dads. And remember, this is equal protection doctrine. That a fundamental right can be a violation in one of two ways. One way can be Zablocki versus Red Hale or Eisenstadt versus Bayard, that you're discriminating against some Americans in the allocation of a fundamental right. Like voting. Voting would be another good example. Harper versus Virginia. Virginia is just chock full of equal protection cases. Okay? But then you can also argue, and this was Griswold versus Connecticut, that was the end of Judge Bork, or Bowers versus Hardwick, if you come out the other way, or Lawrence, that the state is denying a fundamental liberty, a fundamental right, and it's got to show a compelling state interest to do that. Okay, so what would be the right analysis? If a state just simply said we're no longer get on the marriage business because it's a sectarian term, has patriarchal background, anti-gay background, whatever, and we'll give everybody civil unions. I think sure that would be constitutional because it certainly wouldn't violate the equal protection clause now that everybody gets the same thing. You could argue, and many Americans believe, that it would violate the due process clause. In other words, many Americans believe that the state has an obligation to provide marriage specifically as a way of structuring their lives. And this is not a dumb argument. I don't think it's a winning argument, but I think it's completely understandable and indeed even noble argument. If you believe what I said at the beginning, which I'm sure that Governor McDonnell believes, y'all's new governor, as of a few days ago, that if you define the civil right as this triadic, now how good is that? The trinity of religious, cultural, and legal, all called marriage, all working together to create this institution of interpersonal commitment, right? And the argument would be that is powerful, it's normative, and it's fundamental to both society and civic society, the polity. Then you can make an argument that is so fundamental. Remember, that's the due process clause. Ordered liberty. What is fundamental to ordered liberty in the United States? It's usually been used in criminal procedure cases. But you could easily see that as saying there's a fundamental right to marry. Even though marry is not in the Constitution, the word is not in the Constitution, but it certainly was fundamental to the United States when the Constitution was framed. And I think it remains a fundamental positive institution And the argument would be it's a normative institution as well. And the state cannot abolish it or try to rename it, which would disrupt this Trinitarian, maybe I should say triadic, so I won't be too sectarian, but this triadic relationship which makes marriage this powerful ordering force. Okay? So those would be the arguments. And again, your idea would easily pass, I think, the Equal Protection Clause, but you could construct a substantive due process clause liberty argument this would violate. And again, I think it could be an intelligent argument. I don't think this would be a bigoted or horrible argument. It would be a very intelligent argument. Now, then the gentleman who left, what about polygamy and all that sort of stuff? Well, the fact that the best witness, I think the only witness that I could quite understand in this case is Nancy Koch, my former colleague at Yale, who's this spectacular historian. Public Vows is her, I recommend to everybody, just as an American or whatever it is you are, this is a great book about marriage, history, Nancy Koch, C-O-T-T. And her testimony was, look, marriage has evolved every generation in America. It's evolved dramatically, not marginally, but dramatically. You know, in the 19th century, marriage entailed coverture. If you were a woman married to a man, you had could not own your own property for the most part. Not absolutely, but for the most part. Could not enter into contracts, couldn't sue your husband. You could not complain of rape within the marriage, et cetera, et cetera. And there were lots of other things. That's the tip of the horrible iceberg. That was marriage. In Virginia, in most states in the 19th century, for most of the 19th century. Obviously, that is not marriage today. Marriage has been a great exclusionary factory. People with disabilities excluded, racial minorities excluded, gays and lesbians excluded. It's been a very exclusionary institution for most of its history. So Kott's argument in her book, which is an excellent magisterial work in history, is that marriage is an evolving institution. And the evolution is overwhelmingly driven socially. And the law follows, ratifies some, then ratify others. So my view is take a look at, so for example, cousins. Traditional religious belief, I don't know how all the religions approach this, but traditional religious belief has been that cousins cannot marry. And honestly, I think that's changing in the law. When I looked at this a few years ago, I think it was 4/5 of the states would not recognize cousins, would not give licenses to first cousins. First cousins. Second cousins, I think you're okay.
I think 4/5 of them do allow first cousins to marry, at least 2/3 of them.
No, I'm saying 10 years ago when I first looked at this, 4/5 of them didn't allow it. And there's a sea change. This is unremarked. But this is a huge change in the definition of marriage. Huge change. And my suspicion is, this is not like the miscegenation debate or the same-sex marriage debate. My suspicion is that most Americans don't deeply care. You know, there might be a few theologians who are like, you know, draw the line on those first cousins, or we'll be like the Habsburgs. And then there are others who maybe are first cousins and like, I want to get married. But I think most of us not only don't deeply, but don't even know, even the lawyer types. So we're going to see that. Relations of affinity. In other words, you're related by marriage. You're starting to see, you've seen for the last 30 years, you're seeing lawsuits, not a lot, and maybe you'll never see a lot, I don't know, but of young people who maybe grew up together, but they're no blood relation to one another. They're part of blended families, and they want to get married. Now that raises all sorts of interesting issues. But there's a Colorado decision, the Israel case, where the court actually said it's illegitimate for the state to deny this particular couple a marriage license, struck it down on some kind of constitutional ground. The polygamy thing, I just don't see the polygamy thing. I don't see any great, in Denmark, which has had the oldest statute, no polygamy. No one wants polygamy in Denmark. It's a lavender herring, it seems to me. And indeed, the main advocates of polygamy are these Mormons, which is the most anti-gay denomination. I mean, I realize it's a French group of Mormons, but this is like the Mormon thing, right? And so I just don't see the polygamy thing. I don't see any great groundswell for polygamy. Although I will say this, and this is not based upon, you all are going to know more about this than I am, because I don't watch TV and don't have cable. But Big Love, everybody knows about Big Love, except for me. But I know about Big Love, but I've never actually watched it. And it's supposed to be a really excellent program. Everything I've heard about it seems like it's interesting. It's not a caricature, is what I gather, et cetera, about a polyamorous family, right? So it's conceivable. I think this has almost no connection with the gay marriage debate, but it's conceivable, mainly for these Mormon things. The reason I'm not in favor of polygamy is the same reason I favor same-sex marriage. I endorse the sex discrimination for same-sex marriage. I think it's exactly like Loving doctrinally. Remember Loving, it was a race discrimination. If a white person wanted to marry a black person, the variable that produced the discrimination was the white person's race. White person had been black, you could have gotten married. So I'm denied my marriage license because of my race. If a woman wants to marry another woman, what's the regulatory variable? It's her sex. Duh. If she were a man, she'd get the license. If she's not a man, she doesn't get a license. It's her sex, right? So it's a sex discrimination in exactly the way that Loving versus Virginia is a race discrimination. Now, a lot of people don't agree with that, including, I think, all 9 of the Supreme Court justices, because they see it as chicanery and a trick argument. They say, oh, no, Bill. No, that's not the same. Because the miscegenation statutes were aimed at racism and black people. And I said, no, that's not true. Who were the victims of the miscegenation statutes? They were not black people. Most blacks actually supported the miscegenation statutes at some point. Instead, they were miscegenous sexuals. People who were attracted to someone of the opposite of a different race. Miscegenous sexuals, to use a really bad, clunky, horrible term. Now, the way you can see it as a race statute is that the underlying ideology was race purity, which, of course, is the object of Brown. That race purity is not an acceptable state justification. So Loving is correct. But same-sex marriage is exactly the same. So the immediate victims of same-sex marriage bars, of course, are not miscegenous sexuals, but homosexuals. But what's the underlying ideology? Don't call it homophobia, because it's not. The underlying ideology of same-sex marriage bans is not homophobia. Instead, it's sexism. It's rigid gender roles. It's the idea that if you're a woman and the way your ultimate fulfillment in life, your romantic fulfillment, what the state is going to encourage, what the state is going to endorse, the child raising thing, can only be done by marriage to a man. Can never be done by marriage to a woman. Now that's rigid gender roles. That's gender role conformity, which is sexism, according to the U.S. Supreme Court. That's Craig and Boren. It's all of those sex discrimination cases in the 70s. That's definitional of sexism, is that people are forced or expected to conform to rigid gender roles. Now, that, by the way, also explains why I think America is not ready for same-sex marriage, is that America, the deepest sexism in America is the sexism of marriage, the complementarity idea. So it's not religion. I think religion has actually nothing. Religion is totally epiphenomenal. You can find biblical passages to support almost anything, and people do. So religion is merely the vocabulary in which people are expressing their anxieties. And I think the reason people oppose same-sex marriage, part of it is sexual hysteria, is that people believe that sexuality is Pandora's box. In fact, Pandora's box is probably literally a metaphor about sexuality. When Pandora opens the box, what emerges is all of these sexual things. And so a young woman had best not open the box. And you understand the metaphors there, I'm sure, right? So a lot of it is sexual hysteria. And then I think a lot of it is gender role. That the deepest, psychologically, the deepest gender role conformity in America is the complementarity idea. That men and women are biological complements. And what flows from that is they're also gender complements. And complementarity is the basis of marriage. And the fact that the complementarity also produces children, because it's procreative, is like, makes it perfect. And then if you're religious, you throw in God approves. But you don't even need the God approves, because it's an elegant argument, right? Now, same-sex marriage, and that this is the deepest root of sexism. And the part of sexism that Americans fundamentally have not given up and don't even recognize. And that's why same-sex marriage is a deep, deep debate, in my opinion. But it's also a debate that I think is a debate about sex discrimination, patriarchy, and gender roles. And that same ideology, of course, is exactly the ideology that is most critical of polygamy. Because polygamy in the United States would tend to be wealthy men. This is the way it was for the Mormons in the 19th century. Wealthy men with plural wives. Now, I realize in the era of Jane Fonda, you would also have wealthy women with numerous himbos. And that's, okay, so you'd have that. But it would still be mostly Donald Trumps. Not even admirable like Jane Fonda is, or even like in good shape or anything like that, or smart. You'd have like Donald Trump with phony hair and bad values and whatnot, and not good exercise, right? So you'd have wealthy men and a series of wives, probably in descending order of age. You keep marrying younger and younger and younger, which is a feminist nightmare because it's a very bad deal for the wives. It is symbolic replication of the harem, so on and so on and so on, right? But that might change in the next generation. You can imagine the Jane Fonda model becoming a bigger model. And the Big Love thing apparently, portrays the possibility that the wives can be friends. And I think that sounds realistic to me. It sounds like a possible scenario, like a deeper relationship, et cetera, et cetera, et cetera. But my objection to polygamy is based upon feminism. And I think other.
I have a question about the triad argument. If that were to be advanced and eventually accepted, wouldn't that require the accepting court to kind of decide that the majority of religions which say marriages between a man and a woman are more legitimate or better than the minority of religions that don't care or say marriage is just a monogamous relationship?
I don't think a court would say that, because remember, there are a lot of things the court has ruled that some religions win and other religions lose. And the court just simply says, we're deciding this way, we don't care how the religions shake out, and we're perfectly happy and comfortable with the fact that some religions are winning and some religions are losing. But they're not winning or losing because of their religiousness. They're winning or losing because we think this is the way we read the Constitution, and this is the way we read our precedents. So, for example, the court, I think, has upheld, this is back in the Warren Court era, I believe that this is still probably good law, when states like Virginia had Sunday closing laws. And there probably are still Sunday closing laws, for at least some things like alcohol. Those have been upheld as constitutional against Establishment Clause and other kinds of objections. But the court didn't see that as any kind of endorsement of religions that celebrate Sunday, because like Jews don't celebrate Sunday as the holy day. They're Saturday's Sabbatarians, right? Or Saturday religions. So it was not seen as like Jews are losing, this is a victory for Christians over Jews. It was merely that the state has the discretion to have certain days that they're going to close certain businesses, and we're not going to find this violates the Constitution, for better or worse. Robin, is that still good law?
I think it is, Bill, yeah.
It's rather fusty precedent, I suspect.
But you could look at Kent Greenawalt's volumes. He has a 2-volume treatise on religion and the Constitution, and I think you'll find his cases in the Establishment Clause volume, volume 2, or maybe volume 1, I forget which.
And then, of course, there'll be a lot of lower court decisions. It's an old, like 60s, early 60s Warren Court decisions, etc.
Well, at the same time, isn't that, I guess the foundational argument in those cases were that any day of rest, it could have been a Thursday, the state could choose, and it just happened to benefit Christian, Judeo-Christian religions. But if you're going with this triad argument, that the fact that most religions believe a certain thing is a foundation of that argument.
Yeah, I like that. Well, you're right. So it's a different case, and I like that. And I doubt that the Greenwald volume takes a position on this issue because it probably hasn't occurred to him. Here'd be how you could still uphold it. And remember, my position is I don't think the court is doing any discernible normative work in America. I think occasionally they've done some discernible work in America. I think the voting cases did some work, particularly one person, one vote. I think that did a lot of work. And that might be about it for me. So I don't think the court is doing any normative work in America. And I think the court would go along if there were like a strong political consensus. There's not, and they have a lot of discretion. So here's what they could say. What they could say is the legislature, abolishes marriage, blah, blah, blah. And the court says, well, what they would say is that this is so fundamental to American history and the history of American law as to be key to ordered liberty as defined historically. Now, the fact that historically, in 1789, the Constitution, and then 1791 is the First Amendment, historically, America was overwhelmingly a Christian nation, and mostly Protestant, but Maryland Catholic, etc. And so, religion was both secular and religious in 1789. But really, a lot of the power of religion would have been its association. A lot of the power of marriage would have been its association with religion. Maybe even more in 1789 and 1791. 1791 when the Establishment Clause is added to the Constitution, than it is today. So that would be their dodge. Now I think that would be their dodge if they really wanted to do that. But honestly, I think even the current court, Justice Scalia, who is the most devout justice, well, he and Thomas, there are a lot of devout justices, but let's say Scalia and Thomas, who are two unquestionably devout justices, and Catholics, and love marriage, right? And I bet you, if I gave them this little triadic argument, there'd be much shaking of the head. And that's the way Scalia usually is with me. Like, oh, Eskridge, you should be put in jail for that. So, yes, you've seen the way, Eskridge. He gave me a copy of his book, Matter of Interpretation, and inscribed it. And we actually are friends. He inscribed it with hopes for your conversion. Now, I don't even know that. I don't think he knew that I was gay at that point. So it would have a creepier, I'm not kidding. And that's one of the witnesses in this trial was this kid named Ryan something, whose parents sent him to gay conversion therapy, and he gave, I'm sure it was a lurid description of conversion therapy, right? So I don't think Scalia had that in mind. But I bet you this triadic argument, I think Scalia would recognize it and sort of say, yeah, this is a really good point, etc. But I don't think Scalia and Thomas, for example, would strike down a state statute which abolished marriage and created civil unions or domestic partnerships for everybody. Because I think Scalia would say he thinks this ordered liberty thing is just an invitation for judicial adventurism. Now, he does some of his own little adventurism from time to time as well. But I think he really hates the substantive due process stuff. And even though you can make this tradition argument and so forth, I think he would say, no, this is not something where I think the courts should really get involved. And legislatures have a lot of discretion along those lines. And if the people are really going to go along with this nonsense, then, Antonin Scalia, I'm not going to stand in their way. So I'm not sure there would be any votes for this argument. I'm just saying that it's the way you would make the argument. And it's not, I don't think it's a limiting argument. I think it actually, has a lot of possible virtue to it. But I'm not a great believer in the Supreme Court ordering American society. And I think they're mostly, fairly acquiescent when the people are still churning things. Others. Speeches.
I want to ask, do we have class or anything?
We have the room until 4.
Okay.
Mm-hmm. But if there's no more questions, we can wrap up and people can have seconds back there.
Excellent. Well, Kelly, thanks for inviting me to this. And Professor Wilson, thanks for inviting me to the faculty
Thank you
workshop.
for coming.